Hi, this is Joshua Clark from Armoured Suits Criminal Defense Lawyers. Today I'm going to be talking about impaired driving. Obviously, impaired driving is a very serious offense and one that we see all the time, day in and day out in our courts. There are mandatory charging policies, which means that the police, when they believe that an offense has been committed, are required to arrest and charge the person with an offense. Gone are the days of just keep it between the lines and let it go. There's two main kinds of impaired driving that we see: alcohol related and drug related. And of course there are differences depending on whether it's considered to be alcohol or drug impaired driving. So just to list the types of offenses, we have impaired driving. Now that typically is the physical manifestations of impairment. Wobbly, slurred speech, glossy eyes, dilated pupils, bad driving, all the physical signs is the impaired driving count. Then, depending on whether it's alcohol or not, you can have the 80 and over offense, and that refers to 80 milligrams of alcohol per 100 milliliters of blood. If you're at 80 or higher, you've committed the offense, allegedly. And then the others that we see are essentially derivatives. The others are care and control, which means you're not actually driving, but you have the ability to put the vehicle into motion, and you're behind the wheel impaired. Okay, doesn't require you to actually drive. And the last one that we see is fail or refuse to provide a breath sample. So if you are required to provide a sample and you either refuse to do it, or you exhale instead of inhale, or inhale versus exhale, and it provides an error, you can still be arrested and charged with the same offense. So you don't get any credit for faking it. You're often quite often better to provide a sample.